Good morning. I hereby call to order this 10th meeting of the Pennsylvania Public Utility Commission for the year 2022, and I ask that everyone please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We thank everyone for joining us for today's meeting, and also for those of you that are watching us through our live stream. At today's meeting, which is open to the public, the Commission will act on various matters. There's no opportunity for the public to address the Commission at these public meetings. The public meeting motions, statements, and video will be available on the Commission's website later today. Our first matter on this morning's agenda is the approval of the minutes for July 14, 2020, and Commissioner Unora will be recognized as the editor of the minutes.
Thank you, Madam Chair. I have reviewed the minutes of the July 14th, 2022 public meeting and move that they be approved as submitted.
You have heard the motion for the approval of the minutes. Is there a second?
Second.
Second by Vice Chairman Coleman. I assume there's no further edits or discussion. All those in favor, please say aye.
Aye.
Aye. Any opposed? The minutes are approved 3-0. And now I will turn it over to our Secretary of the Commission, Rosemary Chiavetta, to lead us through this morning's agenda.
Good morning, Madam Chairman and Commissioners. Your various bureaus and offices have prepared the following agenda items for your consideration. Therefore, let us begin on page 1 with matters presented by Acting Executive Director Gramola and the Bureau of Administration. It is recommended that the Commission adopt in an omnibus motion both items on page 1, beginning with the general assessment for the fiscal year starting July 1, 2022, and ending June 30, 2023 for each applicable utility and pipeline operators under Act 127, and continuing the omnibus on page 2 to include both assessment items for electric and gas suppliers and the Pennsylvania One call, and ending the omnibus motion on page 3 with the adoption of the assessments for the Office of Consumer Advocate and for the Office of Small Business Advocate.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Unora. Any discussion? Hearing none. All those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Turning to page 4 and matters presented by Director Monahan and the Bureau of Audits, it is recommended that the Commission adopt in an omnibus motion both items on page 4, beginning with the management and operations audit of the PECO Energy Company and ending the omnibus with the generation supply adjustment audit for the PECO Energy Company.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Unora. Any discussion? Hearing none. All those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Turning to page 5, it is recommended by Director Bechtel on the Bureau of Consumer Services that the Commission adopt the proposed order regarding the petition for reconsideration filed by Peoples Natural Gas Company, LLC, and the Peoples Gas Company.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Unora. Any discussion? Hearing none. All those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Turning to page 6 and matters presented by Director Sophie and the Office of Special Assistance, it is recommended that the Commission adopt in an omnibus motion both items on page 6, beginning with the formal complaint of Richard Culbertson versus Columbia Gas of Pennsylvania, and continuing the omnibus on page 7 to include both items on page 7, and both items on page 8, and both items on page 9, ending the omnibus with the formal complaint of the Bureau of Investigation and Enforcement versus Golden Triangle Construction Company.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Any discussion? Hearing none, all those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Turning to page 10, it is recommended that the Commission adopt the proposed opinion and order in the formal complaint of Courtney Matkovich versus Verizon North, LLC.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Any discussion? I do have comments that I asked to be placed into the record in its entirety, and I will abbreviate them for your hearing. The case before us today concerns the formal complaint filed on October 13, 2020, alleging that Verizon North LLC failed to meet broadband available under Chapter 30 of the Public Utility Code. Chapter 30 requires that incumbent local exchange telecommunication companies make broadband available within 10 days of a request at speeds of 1.5 Mbps down and 0.128 Mbps up. And then the complainant, Courtney Matkovich, alleged that the respondent failed to provide Chapter 30 speed at her residence. The complainant relied on the broadband to facilitate her telework for 9 nursing homes and other purposes such as teleeducation. The respondent's answer claimed that the Commission lacks jurisdiction over broadband and that its efforts to address the complainant's concerns about the availability of broadband at Chapter 30 speeds was reasonable. I agree with the ALJ's determination that the Commission has jurisdiction over the respondent's legal obligation to make broadband available at Chapter 30 speeds within 10 days. The Commission has spent several years now educating the public about this mandate. The Commission has posted a broadband Bill of Rights on our website in acknowledgement of the increasing importance of broadband in modern society. In the instant case, the respondent's technician was able to demonstrate that the Chapter 30 speeds were available at the network interface device, or the NID, but not inside the dwelling. I agree with the ALJ that the focus of service for broadband availability under Chapter 30 and Section 1501 of the Code should be whether the service is reasonably continuous so as to be available inside the dwelling as opposed to available at the NID. The complainant met her burden of proving that service was not available in the premise. The respondent was not able to rebut that, showing with evidence proving that the service was available inside the premise. I disagree that broadband capacity constraints beyond the remote out to the network itself are not within the respondent's control. Capacity constraints must be addressed whenever they interfere with meeting the Chapter 30 speed mandate. It is not confined to the 11,000 feet from this consumer's premises to the remote. So for these reasons, I will be concurring in part and dissenting in part. Any further comments or discussion on the matter? Hearing none, all those in favor, please say aye.
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 Aye, noting that I'm concurring in part. Any opposed? Note also that I'm dissenting in part. So the vote is actually 3-0, just noting my dissent in part.
Continuing on page 10, it is recommended that the Commission adopt the proposed opinion and order regarding the formal complaint of Glen Riddle Station, LP versus Sunoco Pipeline, LP.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Any discussion?
Madam Chair, I do have a motion.
Commissioner Yunora.
I ask that my motion be entered in the record as if I read it in its entirety. Before the Commission is Sunoco's petition for reconsideration of our June 16, 2022 order. In that order, the Commission found that Sunoco's construction activities violated the Public Utility Code and the PUC regulations by 1, creating instance of unreasonable high noise level, 2, ascertaining emergency fire responder access and hazards, and 3, failing to adequately communicate with Glen Riddle residents. On July 11, 2022, the Energy Association of Pennsylvania, or EAP, filed a letter in support of Sunoco's petition. EAP questioned the Commission's noise and emergency responder access violations findings. The EAP especially noted that the ordinary construction activities and the electric and natural gas utilities regularly exceed certain noise decibel levels, including the use of jackhammers. EAP also noted that the presence of large construction vehicles and high levels of truck traffic are regularly expected in utility construction activity. Given this new EAP information, I believe that the Commission overlooked that utility construction noise emissions above certain decibels occur frequently. Additionally, I believe the Commission overlooked the large construction vehicles and truck traffic are normally utility construction occurrences which may temporarily delay emergency and fire responder accesses accordingly. I believe that the reconsideration is warranted regarding our noise and emergency responder access findings. These types of utility construction activities are imperative to maintaining critical infrastructure and are necessary to ensure that the utilities are adequately performing their duties to provide reasonable, safe, and reliable adequate services. Regarding Sunoco's communication with the construction activities, I believe the Commission appropriately found that Sunoco failed to adequately communicate with residents of Glen Riddle properties for reasons set forth in the June order. Therefore, I move that 1, the petition for reconsideration filed by Sunoco is granted in part and denied in part, consistent with this motion. 2, that the Sunoco shall pay a civil penalty of $3,000 based on its failure to adequately communicate with residents of Glen Riddle properties regarding its construction activities. And 3, that the Office of Special Assistance prepare an opinion and order consistent with this motion. Thank you.
You have heard the motion by Commissioner Unora. Is there a second?
Second.
Second by Vice Chairman Coleman. Any discussion on this motion? I do have comments, and I ask that my comments be placed into the record in their entirety, and then I will abbreviate them for your hearing. On December 2nd, 2020, Glen Riddle Station filed a formal complaint alleging that Sunoco's pipeline construction of the Mariner East 2 and Mariner East 2X pipelines across its properties and adjacent to its 124-unit apartment buildings caused severe disruption to its residents, sufficient to constitute unreasonable service by the utility. Glen Riddle claimed that Sunoco's actions adversely affected property, parking, and traffic safety, created an unsafe construction work site, shirked government-mandated pandemic safety protocols, caused a water line break, depriving residents of water service, raised structural and storm damage concerns, and that the utility failed to communicate regarding a potentially hazardous leak. On June 16, 2020, the Commission denied Sunoco's exceptions, sustained the ALJ's determination that Sunoco provided unreasonable service, and upheld the imposition of the $51,000 civil penalty. On July 1st, 2022, Sunoco filed the instant petition for reconsideration. The first step of the DUIC analysis is determining whether a party has offered new and novel arguments or identified considerations that appear to have been overlooked or not addressed by the Commission in its previous order. Each averment of Sunoco's reconsideration petition was previously raised in both content and chronological order in Sunoco's exceptions and rejected by the Commission's disposition of the exceptions in our June 16, 2022 order. By failing to allege any new or novel argument or matter overlooked by our June 16th order, Sunoco fails to assert any basis for a grant of reconsideration. I wish to clarify that my vote on June 16, 2022 to uphold the $51,000 civil penalty was based upon the totality of the evidence submitted at this docket. My vote was in no way intended to impose a broad or overreaching set of construction standards upon our regulated utilities. In fact, the June 16th order addressed that very claim made by Sunoco in its exceptions. As I stated previously, all issues raised by Sunoco's petition were previously raised and addressed. Sunoco has not met the DUIC standard. Sunoco's actions at Glen Riddle were so disruptive to the residents living there that it interfered with Glen Riddle's ability to run its business. I believe that had proper public notice of construction activity been given to Glen Riddle as required by our regulations, an accord could have been reached between the parties regarding construction time and possibly ways to minimize disruption. Sunoco's petition for reconsideration should be denied, and for these reasons, I will be dissenting on this motion. Any further discussion on the motion?
Chairman, I just had maybe a couple of comments I'd like to share. And each case that comes before this commission has a unique set of facts and circumstances, and that's certainly the case with this matter before us this morning. For me, I don't know that it's really as much about Sunoco and Glen Riddle as it is about the point that both you, Chairman, and Commissioner Unora have indicated in your comments and statements, or in the motion. And that is, I think there's a bigger piece here that we need to focus on, and that is the content of the letter that came from the Energy Association. I found extremely compelling that we need to be careful, and in fact, this caused me some pause to say we want to be certain of what we're doing here, that we don't create a fact pattern that applies to the regulated utility as a whole. And this morning, I'm a little concerned about that we really do not have a noise regulation here at the Commission, a decibel maximum at construction sites. So it's, in some cases, a bit arbitrary to make a determination that using a jackhammer on one job site is above a noise threshold and on another it's not. I think there are some common fact patterns and questions of law in this case that we need to take into consideration. When I think about traveling from here to my home and going up 2nd Street, and I'm sure many of you have seen construction on that street, and I can't tell you how many times I sit in traffic and I listen and watch, and they're jackhammering, and there is a significant amount of congestion and truck traffic and multiple contractors doing their work in the street. And they're doing the work for the greater good of the community and for all those they serve. So I am sympathetic to the matters that have been raised this morning in terms of noise and traffic congestion specifically, but I also think we need to be careful in not setting a precedent that will be applied across all industries. And for that reason, I'm going to be voting in favor of Commissioner Unora's motion this morning. Thank you.
Thank you, Vice Chairman Coleman. Any further discussion? Hearing none. All those in favor, please say aye.
Aye.
Any opposed? Voting in the negative. The motion passes 2-1, noting my dissent. Oh, on matter as amended by the motion. I almost forgot that, but I didn't. Are we okay with taking the previous roll call? Seeing that the matter as amended passes 2-1, noting my dissent.
Turning to page 11, it is recommended that the Commission adopt in an omnibus motion both items on page 11, beginning with the application of Aqua Pennsylvania wastewater, and continuing the omnibus on page 12 to include both items on page 12, and continuing the omnibus on page 13 to include both items, ending the omnibus with the application of Mo Care Transport, LLC.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Unora. Any discussion? Hearing none. All those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Turning to page 14, and matters presented by Director Diskin and the Bureau of Technical Utility Services. It is recommended that the Commission adopt the proposed order in the application filed by PennDOT for approval regarding a rail crossing in Northampton County, Pennsylvania.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yonora. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 3-0.
Continuing on page 14, it is recommended that the Commission adopt the proposed order in the application filed by Sprint Communications Company, LP, to discontinue and abandon service in Pennsylvania.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yonora. Any discussion?
Chairman, I do have a motion on this matter.
Vice Chairman Coleman.
Thank you. And I would ask that my motion be entered into the record as though I read it in its entirety. Before the Commission for consideration and disposition is the application filed by Sprint Communications Company requesting to abandon its certificate of public convenience in the Commonwealth of Pennsylvania. Sprint currently is certificated to provide telecommunications service in Pennsylvania as a competitive local exchange carrier, an inter-exchange carrier, and an IXC reseller. Previously, the Commission granted Sprint's request to abandon and discontinue its IXC service to residential customers. Sprint now proposes to fully abandon and discontinue its provision of CLEC, IXC, and IXC reseller services within Pennsylvania. Considering Sprint's averments regarding the abandonment of its legacy service and its VoIP-only nature of the service it offers to Pennsylvania, I agree that Sprint is no longer proffering jurisdictional public utility telecommunications services. Therefore, in accordance with Pennsylvania's VoIP Freedom Act, I move to approve Sprint's application to abandon its certificate in Pennsylvania. Under the Act, the Commission is prohibited from regulating or acting in a manner that has the effect of regulating the rates, terms, and conditions of VoIP service. Requiring Sprint to maintain its certificates results in a continued imposition of numerous regulatory compliance obligations on it. Such a result equates to regulating having the effect of regulating the rates, terms, and conditions of Sprint's VoIP service, which ostensibly is prohibited by the Act. Consequently, Sprint does not need certification to offer its VoIP services in Pennsylvania. Nevertheless, the Commission retains limited jurisdiction over VoIP service under the VoIP Freedom Act. Specifically, the Act preserves the Commission's authority over interconnected VoIP service for, among other things, Pennsylvania universal service purposes. Therefore, in accordance with the preserved authority under the VoIP Freedom Act, and as a condition of the approval of the application, Sprint shall be required to continue to report its total gross intra-VoIP revenues for PA-USF assessment purposes, and shall be required to continue to participate in the Pennsylvania USF, and shall be assigned a new utility code to facilitate its participation. As I noted that upon abandonment, all rights and privileges as a public utility existing under Sprint's certificates in Pennsylvania, including but not limited to all rights and privileges with eminent domain authority, zoning exemptions, and public right-of-way occupancy shall be revoked. Therefore, I move that the application of Sprint Communications Company, LP, for approval of the abandonment or discontinuation of telecommunications services to the public in the Commonwealth of Pennsylvania is conditionally approved, consistent with this motion, and that the Bureau of Technical Utility Services prepare an order consistent with this motion. Thank you.
Thank you, Vice Chairman Coleman. You have heard the motion offered by Vice Chairman. Is there a second?
Second.
Second by Commissioner Yonora. Any discussion on the motion? I do have comments, ask that they be spread upon the record in their entirety. And I won't read the whole thing. I know you guys have better things to do, right? Not really. You want to be here, right? Okay. In looking at this motion, I think that the Commission should more thoroughly consider the broader issues raised in the application through a tentative order issued to the public for comment. Important issues of first impression include certification, assessments, and the Commission's authority on intercarrier compensation, as well as 911 and protected services provided under it. I would have preferred that the Commission solicit comment prior to making a final decision, and a few of the questions that I would have preferred to see comments on are the following. First, the VoIP Freedom Act retains commission jurisdiction in at least 4 areas: protected services provided under the tariff, intercarrier compensation, 911, and state universal service. Other than assertion of commission jurisdiction over a certificated carrier, what vehicle is available under the Public Utility Code to enforce these mandates? The second question is, in the absence of a commission-issued CPC, would uncertificated fixed interconnected VoIP service providers be able to obtain interconnection agreements with ILECs and LECs so that the interconnected VoIP consumers are able to connect to the public switch telecommunications network for the completion of their calls? 3, what provisions in the Public Utility Code and this statute preclude treating VoIP when it is provided under a commercial agreement as a protected service provided under tariff? 4, the applicant's request to abandon service is premised on the assertion that the Commission lacks jurisdiction over VoIP. How can that assertion be reconciled with the language preserving Commission authority in the VoIP Freedom Act to sustain a grant of abandonment? And the last question, a CPC generally provides, among other things, zoning exemption, access to public and private rights of way to install, repair, and improve existing facilities, interconnection for call completion, pole attachment rights, an exception from remission of the sales tax, and access to the Commission to resolve disputes between carriers and with consumers. Following abandonment of the CPC, what vehicle would the applicant have available to obtain these benefits to serve 5G and consumers served under commercial agreements? So given the lack of consideration of what I consider to be these very important questions, I am not able to support granting the application to abandon the service, and I will be dissenting on the motion. Any further discussion on the motion? Hearing none, all those in favor, please say aye.
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 Any opposed? Nay. The motion passes 2-1. And if there's no objection, we can take the previous roll call on the matter as amended. Seeing no objection, the matter as amended passes 2-1, noting my dissent.
Turning to page 15, it is recommended that the Commission adopt in an omnibus motion both items on page 15, beginning with the application of the York Water Company to acquire certain water assets in York County, and continuing the omnibus to include both items on page 16, both items on page 17, all 3 items on page 18, and including and ending the omnibus at the top of page 19 with the application of CPV Retail Energy LP.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Any discussion? Hearing none, all those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Continuing at the bottom of page 19, it is recommended that the Commission adopt the proposed order regarding the application of PulseNet to discontinue and abandon service within Pennsylvania.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Any discussion? I do have comments I ask to be placed into the record in its entirety. Once again, I will abbreviate my statements. The case before us today concerns a petition to abandon service premised on the claim that the public utility is only providing internet service in Pennsylvania, aka retail broadband internet access service. I do not read our prior net speed decision as a complete abrogation of all PUC jurisdiction when it comes to retail broadband internet access service. Chapter 30 authorizes this commission to enforce the incumbent local exchange carrier, or the ILEC, obligation to make broadband available within 10 days. The recent Massilia decision in the United States District Court for the District of Columbia remanded a preemption decision of the FCC, which prohibited any state regulation of intrastate retail broadband internet access service back to the FCC for more deliberation. That leaves states effectively able to exercise jurisdiction over intrastate broadband. Two decisions, the RTCC versus PAPUC and the more recent Crown Castle versus PAPUC decisions hold that transmission service can be a form of wholesale telecommunications public utility service within the Commission's authority, regardless of the services provided over that transmission service. There are pending petitions at the FCC and proposed legislation in Congress that would classify internet service as common carrier public utility service. The federal funding that may come to Pennsylvania under the Broadband Equity Access and Deployment, or BEAD, program could warrant certification of the underlying transmission service needed to provide internet service as wholesale telecommunications service, particularly if that service is used to provide voice over internet protocol service. In our NetSpeed decision, the Commission properly determined whether the public utility abandoning service has been providing wholesale or VoIP services. These are important considerations given the increased importance of retail broadband internet service, recent state and federal efforts to fund broadband deployment in Pennsylvania, and the ongoing issue of how to classify internet service under state and federal law. Although I believe that the application should be granted, I believe that it is important to voice these concerns. So for that reason, I will be concurring in result only. Any further discussion on this matter? Hearing none, all those in favor, please say aye.
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 And I note aye, concurring in result only. Any opposed? The motion passes 3-0, noting that I am voting in concurring in result only.
Turning to page 20, and matters presented by Chief Counsel Hicks and the Law Bureau. It is recommended that the Commission adopt the proposed tentative order regarding the Pennsylvania Relay Service Advisory Board.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yonora. Any discussion? I'm just going to put my hand up slightly. I just gotta laugh, guys, you know. I do have comments to place on the record, ask that they be placed on the record in their entirety, but I will abbreviate them again. No, actually, I'm going to read the whole thing because they're that short. The tentative order proposes amending a 1990 order which established the Telecommunications Relay Service and TRS Advisory Board to eliminate a provision allowing staff to have a voting role on the TRS Advisory Board. I would like to note that this Commission's action to establish the Pennsylvania TRS program was in advance of subsequent federal legislation which imposed that obligation on common carrier telecommunications service providers. I support seeking comments on the proposal to revise our TRS Advisory Board structure. The current TRS board structure has been in place for over 30 years without issue. However, I appreciate the observation regarding a potential ethics concern in the mingling of Commission staff roles on the TRS Advisory Board. I also seek analysis on whether this action is more appropriately warranted in order to harmonize the Commission's approach to the TRS Advisory Board with other advisory boards such as the Consumer Advisory Council and others. Those boards have no Commission staff members in a voting capacity. Any further comments on this matter? Hearing none, all those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Continuing on page 20, it is recommended that the Commission adopt the proposed order in the amended petition for declaratory order filed by the Westover Property Management Company doing business as the Westover Companies.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Any discussion? Hearing none, all those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Turning to page 21, and matters presented by Chief Administrative Law Judge Rainey and the Office of Administrative Law Judge. It is recommended in an omnibus motion that the Commission adopt both items on page 21, beginning with ALJ Vero's and ALJ Chiodo's recommended decision in the Stage 2 compliance plan of the Pittsburgh Water and Sewer Authority, and ending the omnibus with the initial decision of ALJs Johnson and Collins in the joint application of the Peoples Natural Gas Company and Peoples Gas Company, LLC.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Any discussion? Hearing none, all those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Turning to page 22, it is recommended in an omnibus motion that the Commission adopt both recommended decisions appearing on page 22 of ALJ Dunderdale in the joint application of Peoples Natural Gas as well as the Peoples Gas Company's 1307F cost recovery mechanism and joint settlement petition.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Any discussion? Hearing none, all those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
And turning to page 23, it is recommended that the Commission adopt ALJ DeVoe's recommended decision in the 1307F filing by Columbia Gas of Pennsylvania, proposing a rate decrease in purchased gas costs and joint settlement.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Any discussion? Hearing none, all those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Madam Chairman, that concludes regular agenda items. Turning now to the carry-in agenda. On page 1 of the carry-in agenda, Madam Chairman, it should be noted that the first item, the formal complaint of the Bureau of Investigation and Enforcement versus Verde Energy USA, has been postponed to the public meeting of September 15, 2022. Turning to page 2 of the carry-in, it is recommended by the Bureau of Technical Utility Services that the Commission adopt the proposed opinion and order regarding the petition filed by UGI Utilities Electric Division for approval of its second long-term infrastructure improvement plan.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 3-0.
Madam Chairman and Commissioners, that concludes all agenda items to be considered today.
Thank you very much. With no further business to come before us, I will entertain a motion to adjourn.
So moved.
Is there a second?
Second.
All those in favor of adjourning, please say aye.
Aye.
Any opposed? Motion passes 3-0. We are adjourned. Thank you, everyone.